Okay, friends. The next major criticism of the DPSP is the constitutional conflict. As case Andana pointed out, that DPSPs lead to a constitutional conflict between center and the states, between the president, the prime minister, and between the governor as well as the chief minister. Why? Because see, basically the prime minister is more of the political ideology, and the president will more work towards the enforcement of the constitution. According to the center can give directions to the state with regard to the implementation of these principles, and in case of non-compliance can dismiss the state government. Exactly, like emergency and all had a great basis for this. Similarly, when the prime minister gets a bill which violates the directive principles passed by the parliament, the president may reject the bill on the ground that these principles are fundamental to the governance of the country, and hence the ministry has no right to ignore them. The same constitutional conflict may occur between the governor and the chief minister at the state level also. Friends, I hope I am making it very clear to you how these things are working. Next, what is the utility of these directive principles? Despite of the above criticism and the shortcomings, the directive principles are not an unnecessary appendage to the constitution. The constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhvi, an eminent jurist and diplomat, the directive principles are the life-giving provisions of the constitution. They constitute the stuff of the constitution and its philosophy and social justice. M.C. Chagla, this former Chief Justice of India, is of the opinion that if all these principles are fully carried out, our country would indeed be heaven on earth. India then be not only a democracy in political sense but also a welfare state looking after the welfare of its citizens. B.R. Ambedkar had pointed out that the directives had great value because they lay down that the goal of the Indian polity is economic democracy as distinguished from political democracy. Granville Austin opened that the directive principles are aimed at furthering the goals of social revolution or to foster this revolution by establishing the conditions necessary for its achievement. Sir B.N. Rao, the constitutional advisor of the Constituent Assembly, stated that the directive principles are intended as moral precepts for the authorities of the states that have at least an educative value. According to M.C. Sethelwad, the former Attorney General of India, the directive principles, although confer no legal rights and creates no legal remedies, are significant and useful in the following ways. Number one, they are like an instrument of instruction or general recommendations addressed to all the authorities of the Indian Union. They remind of the basic principles of social and economic order which the Constitution aims at building. Number two, they have served as a useful beacon of lights for the courts. They have helped the courts in exercising their power of judicial review, that is, the power to determine the constitutional validity of a law. They form the dominating background of all state action, legislative or executive, and also guide to the courts in some respects. They amplify the preamble which solemnly resolves to secure to all citizens of India justice, liberty, equality, and fraternity. Now, what is the important role that the directive principles play? First, they facilitate the stability and continuity of domestic as well as foreign policies in political, economic, and social spheres in spite of the changes of party in power. See, friends, as I told you that it is very important that DPSPs ensure these principles. They are supplementary to the fundamental rights of the citizens. They are intended to fill the vacuum in Part 3 by providing for social and economic rights. Their implementation creates a favorable atmosphere for the full and proper enjoyment of fundamental rights by the citizens. Political democracy without economic democracy has almost no meaning at all. They enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directive principles. They serve as crucial test of performance for the government. The people can examine the policies and programs of the government in light of these constitutional declarations. They serve as common political manifesto A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be the guide, the philosopher, and the friend in the legislative as well as the executive acts. Now comes the very important topic, that is the conflict between fundamental rights as well as DPSPs. The justiciability of the fundamental rights and non-justiciability of the DPSP on the one hand, and the moral obligation of the state to implement the directive principles, that is Article 37, on the other hand, have led to a conflict between the two since the commencement of the Constitution. In the Champakam Durarajan case of 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and DPSP, the former would prevail, that is the fundamental rights would prevail. Okay. It declared that the DPSPs have to conform to and run as a subsidiary with the fundamental rights, but it also held that the fundamental rights could be amended by the Parliament by enacting the Constitutional Amendment Acts. As a result, the Parliament made the first amendment in 1951, the fourth amendment of 1955, and the seventh amendment of 1964 to implement some of the directives. Moving on. The above situation underwent a change in 1967 following the Supreme Court judgment in the Golaknath case in 1967. In this case, the Supreme Court ruled that the Parliament cannot take away or abridge a fundamental right which is sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of DPSP. The Parliament reacted to the Supreme Court's judgment in the Golaknath case by enacting the 24th Amendment Act in 1971 and the 25th Amendment Act in 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away the fundamental rights by enacting constitutional amendments. And 25th Amendment Act inserted Article 31C, which contained the following two provisions. What are the two provisions? Number one, no law seeks to implement the socialistic directive principles specified in Article 39B. 22 and 23 shall be void on the ground of contravention of fundamental rights conferred under Article 14. Please remember, friends, that is, if you want to implement Article 39B, the government cannot state that act as unconstitutional. Sorry, not the government. The court cannot state it as unconstitutional on the grounds that it violates Article 14 or Article 19. Okay. No law containing a declaration for giving effect to such policy shall be questioned in the court on the ground that it does not give effect to such a policy. In the Keshananda Bharati case, in 1973, Supreme Court declared that the second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution. See, friends, you need to remember what basic features are and hence cannot be taken away. However, the above first provision of Article 31C was taken away. 31C was held to be constitutional and valid. Later, the 42nd Amendment Act of 1976 extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39B or C. In other words, the 42nd Amendment Act accorded the position of legal supremacy and supremacy of the directive principles over the fundamental rights conferred under Article 14, 19 and 31. However, this extension was declared unconstitutional and invalid by the Supreme Court in the Minerva Mills case in 1980. It means that the directive principles were once again made subordinate to the fundamental rights, but the fundamental rights conferred by Article 14 and 19 were accepted as subordinate to the subordinate to directive principles specified under Article 39B and C. Further, Article 31, that is right to property, was abolished by the 44th Amendment Act of 1978. In the Minerva Mills case in 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of balance between fundamental rights and fundamental duties. They together constitute the core of the commitment to social revolution, and they are like the two wheels of a chariot are no less than the other. That is, one wheel is not less than the other. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between the two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation by means provided by the fundamental rights. Therefore, the present situation is that fundamental rights enjoy supremacy over the directive principle. This is final. No matter what, if a question is being asked in a prelims exam, answer is very simple. Fundamental rights are supreme, hold supremacy over DPSP. Okay, there is no doubt with regard to this. Okay, moving on. Yet this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles so long as the amendment does not damage or destroy the basic structure of the Constitution. Implementation of the directive principles. Since 1950, the successive governments at the center and the states have made several laws and formulated various programs for implementing the directive principles. These are mentioned below. The Planning Commission was established in 1950 to take up the development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status and opportunities. First example of the implementation of directive principles. Almost all the states have passed land reforms to bring changes in the agrarian society and to improve the conditions of rural masses. These measures include abolition of intermediaries like zamindars, jagirdars, imadars, etc. The tenancy reforms like security of tenure, fair rents, etc. Imposition of ceilings on landholding, distribution of surplus land among the landless labor and cooperative farming. Very good. Moving on. The Minimum Wages Act of 1948, the Payment of Wages Act of 1936, the Payment of Bonus Act of 1965, the Contract Labour Regulation and Abolition Act of 1970, the Child Labour Prohibition and Regulation Act of 1986, the Bonded Labour System Abolition Act of 1976, the Trade Union Act of 1926, the Factories Act of 1948, the Mines Act of 1952, the Industrial Disputes Act of 1947, the Workmen Compensation Act of 1923 and so on have been enacted to protect the interests of the labour section. In 2006, the government banned child labour on the basis of this act only. The Maternity Benefit Act of 1961 and the Equal Remuneration Act of 1976 have been made to protect the interests of the women workers. Various measures have been taken to utilize the financial resources for promoting the common good. These include nationalization of life insurance in 1956, nationalization of the 14 leading commercial banks in 1969, nationalization of general insurance in 1971, abolition of the privy purses in 1971 and so on. The Legal Services Authorities Act of 1987 has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalats for promoting equal justice. Lok Adalat is a statutory forum for conciliatory settlement of legal disputes. It has been given the status of a civil court. Its awards are enforceable, binding on the parties and is final as no appeal lies before any court against them. Khadi and Village Industries Board, the Khadi Village Industries Commission, Small Scale Industries Board, National Small Industries Corporation, Handloom Board, Handicraft Board, Coir Board, Silk Board and so on have been set up for the development of cottage industries in rural areas. The Community Development Program of 1952, the Hill Area Development Program of 1960, the Drought Prone Area Program of 1973, the Minimum Needs Program of 1974, Integrated Rural Development Program of 1978, Jawahar Rozgar Yojana of 1989, Swarna Jayanti Gram Swarozgar Yojana of 1999, Sampurna Gramin Rozgar Yojana of 2001, National Rural Employment Guarantee Program of 2006 and so on have been launched for raising the standard of living of the people. The Wildlife Protection Act of 1970 and the Forest Conservation Act of 1980 have been enacted to safeguard the wildlife and the forest respectively. Further, the Water and the Air Acts have been provided for the establishment of the central and state pollution control boards which are engaged in the protection and improvement of the environment. The National Forest Policy of 1988 aims at the protection, conservation and development of forests. Agriculture has been modernized by providing improved agricultural inputs, seeds, fertilizer and irrigation facilities. Various steps have been taken to organize animal husbandry on modern and scientific lines. Three-tier Panchayat Raj system at village, taluka and Zilla levels have been introduced to translate into Gandhiji's dream of every village being a republic. The 73rd and 73rd Amendment Act of 1992 have been enacted to provide constitutional status and protection to these Panchayati Raj institutions. The seats reserved for SCs, STs and other weaker sections in education institutions, government services and representative bodies. The Untouchability Offenses Act of 1955, which was renamed as the Protection of Civil Rights Act in 1976, the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989, have been enacted to protect the SCs and STs from social injustice and exploitation. The 65th Constitutional Amendment Act of 1990 established the National Commission for Scheduled Castes and Scheduled Tribes to protect the interests of SCs and STs. The 89th Constitutional Amendment Act of 2003 bifurcated this combined commission into two separate bodies, namely National Commission for SC and National Commission for ST. Next, the Criminal Procedure Code of 1973 separated the judiciary from the executive in public service of the state. Prior to this separation, the district authorities like the collector, the sub-divisional officer, the tahsildar and so on used to exercise judicial powers along with traditional executive powers. After the separation, the judicial powers were taken away from the executive authorities and vested in the hands of district judicial magistrates who work under the direct control of the state high court. The Ancient and Historical Monument and Archaeological Sites and Remains Act of 1951 has been enacted to protect the monuments, places and objects of national importance. The primary health centers and hospitals have been established throughout the country to improve public health. Also, special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, Kala-Azar, guinea worm, yaws, Japanese encephalitis and so on. As I told you, Mission Indradhanush is an example. All the government schemes, if you want to write an exam, answer in the exam, all government schemes are examples of DPSP. Laws to prohibit the slaughter of cows, calves and bullocks have been enacted in some states. Some states have initiated old age pension schemes to people above the age of 65 years. India has been following the policy of non-alignment and Panchsheel to promote international peace and security. In spite of the above steps, the central and the state government's directive principles have not been fully implemented and effectively due to several reasons like inadequate financial resources, unfavorable socio-economic conditions, population explosion, strained center and state relations and so on. See friends, these are the primary reasons for not the inability to implement the DPSP. Okay. Next, what are there are certain directive principles outside part 4. Apart from directive principles in part 4, friends, there can be a question in the exam, that is directive principles of state policy are found only in part 4 of the Constitution. No friends, they are not found only in part 4 of the Indian Constitution. They are also found outside part 4. Which of the following are the directive principles outside part 4? Let's see. First, claims of SCs and STs to services. The claims of the members of scheduled castes and scheduled tribes shall be taken into consideration consistently with the maintenance and efficiency of administration in making of appointments to the services and posts in connection with the affairs of the union or a state. That is Article 355 in part 6. Number 2, instruction in mother tongue. It shall be the endeavour of every state and every local authority within the state to provide adequate facilities for instruction in mother tongue at primary stage of education to children belonging to linguistic minority groups. Article 350A in part 17 of the Constitution. Development of Hindi language. It shall be the duty of the Union to promote the spread of Hindi language and to develop it so as to serve as a medium of expression for all the elements of a composite culture in India. That is Article 351 or in part 17 of the Constitution. The above directive principles are also non-justiciable in nature. However, they are also given equal importance and attention by the judiciary on the grounds that all the parts of the Constitution must be read together. Okay friends, with this we have finished this very important topic on directive principles of state policy. I have also talked in detail about the various questions that can be framed from this topic and the importance as to how the questions will be framed and how questions will be asked in the exam. Okay friends, I wish you all the best for your exams. Please keep following our notes and keep practicing questions. You will eventually get through the exams. Okay, thank you friends.